Good afternoon. It is, what is it? October 13th, 1 p.m. This is the Colorado Oil and Gas Conservation Commission. We are set to take up our agenda, which consists of a consent agenda and then the mission change rulemaking part 2, 8, 9, and 12. Before we start out on our agenda, Hearings Manager Larson, if we could have a roll call.
Certainly. Commissioner Gibbs.
Here.
Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Putnam.
Here.
Commissioner Robbins.
Here.
Your Chair, you have 7 out of 7 commissioners present.
Excellent. Thank you. And thank you for that. And welcome, commissioners, and welcome to our 95 participants that are participating with us this afternoon. The first item on our agenda is a consent agenda that has 2 items. Commissioners have reviewed that. Are there any questions about the consent agenda? Seeing none, I would seek a motion on the consent agenda.
I'll move approval of the consent agenda as presented.
Second.
We have a motion and a second. Is there further discussion on the consent agenda? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? The motion carries and the consent agenda is approved. The second item on our agenda is docket number 200600115, mission change rulemaking for 800, 900, and 1200. To set the stage for our participants, we have been engaged in a lengthy rulemaking of implementing Senate Bill 19181. We have gotten through preliminary work for the 200 through the 600, and we have gotten through the 800. We still have to go the 900 and the 1200. And originally, we were going to go into public comment on the staff's proposed draft 1200 series rules. However, we have received a joint motion to continue the 1200 series rulemaking. That motion was filed by the following parties: Colorado Oil and Gas Association, West Slope Colorado Oil and Gas Association, American Petroleum Institute Colorado, Small Operators Society, Occidental Petroleum Corporation, Extraction Oil and Gas, High Point Operating Company, Mallard Exploration, TEP Rocky Mountain LLC, Karis Piance LLC, Kinder Morgan CO2 Company, Noble Energy, PDC Energy, and the Western and Rural Local Government Coalition. It says collection, but I think it's coalition. We also have received a joint response to the joint motion to continue. Reading into the record, the parties that are part to the joint response are the Backcountry Hunters and Anglers, Colorado Trout Unlimited, Colorado Wildlife Federation, and National Wildlife Federation. Collectively, we've referred to this group as the Wildlife Hunting and Angling Groups. Western Resource Advocates, National Audubon Society, Audubon Rockies, Conservation Colorado, Battlement Concerned Citizens, Grand Valley Citizens Alliance, Western Colorado Alliance, Wildlife and Biological Resources Coalition, Sierra Club Earthworks League of Oil and Gas Impacted Coloradans, that's Logic, and the Larimer Alliance for Health, Safety, and the Environment. So, commissioners, and we also have received from our hearings officer, Elias Thomas, I can't remember his last name, a recommended order on the motion. So the first order of business is to take up the joint motion to continue, as well as the response to the joint motion, as well as the proposed recommended order. I think our first question for us is, do we desire to deliberate the merits of the joint motion to continue without the necessity of having further argument, as, you know, like oral argument? on the joint motion or from the joint response. And my position on that is I have read the joint motion. I have read the response. Actually, before I say that, let me provide some additional perspective to our 118 parties. The joint motion is based upon the fact that on Friday, October 9th, staff provided us and this rulemaking collectively with a new redlined 1200 series, a new redline statement of basis and purpose, and some additional factual documents in support of the 1200 series. Okay, so that is the result of that is the joint motion to continue and the joint motion to not continue, basically. Again, I don't believe it is necessary for us to hear oral argument from the parties. I believe they have stated their cases pretty persuasively. They're coming at it from two different angles, obviously. And I've sort of solidified my thoughts on what the appropriate next steps are, but I don't want to be presumptuous. If other folks believe that it would be helpful to have oral argument, we can sort of poll ourselves and see what the majority believes. So first question from me to commissioners is, do you think we need some additional oral argument? Commissioner Gonzalez and then Commissioner Messner.
Thank you, Mr. Chair. Yeah, I'll just respond to your question to us commissioners. I personally, as one commissioner, do not feel a need for oral argument in support of the motion and of the response to the motion. I've read them both and have a very good understanding of what each parties or collectively the joint parties are presenting.
Commissioner Messner. Thank you, Commissioner Gonzalez.
No, I would concur with that. I think they were clear in their filings, as was the hearing officer's recommendation was clear.
Anything else, Commissioner McGowan or Commissioner Najapa? Are you guys comfortable just diving into the merits? All right. Okay. Well, with that, I'll give you my 2 cents, and then we can hear the 2 cents from everybody else and see if we can come to some place on this motion. I, as one commissioner, tend to agree with industry and West Slope local governments that the 10-9 draft contained some refined concepts, including new measurements for the no surface occupancy around certain riparian habitats. I tend to disagree that this was unexpected, and I also disagree with the breadth and depth of the substantive changes as argued by industry and the West Slope rural local governments. I think I see perhaps 8 substantive changes in the red line, many of which I think should be deemed favorable to industry. I also agree with the parties responding that the 10-9 draft represents the ordinary evolution of the rule proposal as it is refined and developed through these proceedings, and that this type of iterative process is consistent with past rule practices, that it should be expected, and that it tends to create a more effective and better final rules. With that, in recognizing the breadth and depth of the additions to the SBP, I think there was some breadth and depth to the SBP, as well as the citations to additional scientific literature. I think it is a better course of action to continue the 1200 series rulemaking consistent with the dates as outlined in the hearing officer's recommended order. I think it's important for us to be successful in this important work, and that the issues with the 1200 series need to be adequately vetted. I think it's equally important to ensure meaningful participation by all involved. And while I think we could have meaningful involvement if we were to move into this week, I think out of an abundance of caution, the better course is to continue. I think this allows all parties more time to review and provide perspective to commissioners. With that, I also acknowledge that the parties have spent time and effort organizing witnesses to testify this week. And I apologize if we end up at a place where we are continuing, but I do think that we would have an ability to have public comment at a later time if we were to move in that direction. I also am inclined to support the additional hearing officer recommended orders with regard to additional briefings on the 10-9 documents. I disagree with industry's request that we should have additional written pre-filed testimony. So that's the perspective that I find myself in. I think we also need to, so I think with that, I will stop and I'll look to see what the initial perspective from my fellow commissioners is. Commissioner Nanjapa.
Thank you, Mr. Chair. Generally, I can concur with the other commissioners as well as the comments that you made. I understand the concerns and agree as well that this is a typical part of our process as the rules evolve. However, I do think that given the fact that it was a holiday weekend, that it did maybe tighten the time frame a bit for some of the parties. And generally speaking, as you often say, Mr. Chair, I think it's better for us to take our time and do this right and make sure that we're hearing everybody and that everybody feels that they've fully understood what we are proposing before we go into our presentations and deliberations.
Thank you, Commissioner Nanjapa. Commissioner Messner.
Thank you, Mr. Chair. Yeah, I generally concur as well. I do think this is a natural evolution of the rulemaking process. I think the staff draft redlined rules that were brought forward on the 9th do show an attempt to address a lot of the comments in the pre-filed submittals or the pre-hearing testimony that we had heard from parties, including a desire to see significantly more scientific evidence to back up the suggested changes in the red line or into the draft rules. And so I think that was provided. So I think in a lot of respects, this is a response to what was asked for by many of the parties. But acknowledging that and understanding that this is a process that we need to get correct. And I think that taking the time in order to do that is important. I'm comfortable with the recommendations that were provided by the hearing officer. I do suggest, if it is possible, to allow for public comment to occur today for folks that are ready to provide that. However, if that's not appropriate, I certainly think there's future opportunities for that. And I think anyone that would be interested in providing public comment today should understand that they do have an opportunity should they want more time to digest the current version of the draft rules, that they certainly have the ability to do that. But if this is the window that they set up in order to provide public comment, I'm comfortable taking that today, but I'm not sure procedurally what that may look like.
AAG or Commissioner McGowan.
Thank you, Mr. Chair. I generally agree with everything that everyone said today, and I think I'm a fan of if it takes a little more time for people to digest and give meaningful feedback, then let's try to provide that. I have my afternoon set aside already anyway. If folks feel like they want to testify this afternoon because of whatever their scheduling commitments were, I'm also willing and able to provide an evening again sometime if that would help. I think one of the motions was concern about people taking time off from work to be able to testify today. So I'm more than willing to take part of my evening off to provide an opportunity so people don't have to find daycare or take time off from work, etc. I guess my other thought to add to all of this is if we do decide to push this out a little bit to give everyone time, I hope that there will be some meaningful discussion from the parties to try to find some common ground and resolution to bring to the commissioners. Because I think there's probably some sticky wickets in there that need to get addressed. And so if folks could pull up their sleeves and try to work together and bring some sort of consensus language, that would be helpful too, if we're going to allow this expanded time.
Thank you, Commissioner McGowan. I second your idea of a public comment during an evening as an avenue for people to be able to provide public comment. I think I'm seeing other commissioners nodding up and down, so I think we can make that happen. I would ask AAG Davenport, our attorney, to provide us with his legal advice about whether it is appropriate for public comment today, given some of the filings and APA or Administrative Procedures Act considerations. AAG Davenport.
Thank you, Mr. Chair. Can everyone hear me? I didn't do it.
Yes.
Okay, thank you. I do have some concern with having public comment today. It's an APA procedural concern. My concern arises from a provision of the APA that was cited in both the joint motion and the joint response in regard to releasing revised proposed rules and statement of basis and purpose no less than 5 days before the hearing. In this case, for the 1200 series, the revised proposed rules and statement of basis and purpose were released 4.5 days before today. The public comment is undisputably part of the hearing. Public comment goes into the record. The commission considers public comment as part of its consideration of the record as a whole in reviewing proposed rules. My preference and recommendation is to not have public comment today. I recommend that because there are differing interpretations of the APA in the joint response and the joint motion. There's no case law that's cited in either pleading in regard to how that's interpreted. I agree more with the interpretation provided in the joint motion that the 5 days applies to revised proposed rules. That's exactly what's in the statute itself. And in order to avoid any issue down the road about whether or not public comments are in the record or out of the record, did the commission technically comply with the provisions of the APA? My recommendation is to adopt the hearing officer's recommended order in regard to its schedule for public comments. And if you choose to adopt the hearing officer's recommended order, not to have public comment today, certainly to ensure compliance with the APA, but also to ensure that anyone who makes public comment has their public comment in the record for this rulemaking.
Thank you, AAG Davenport. Do commissioners have questions for our attorney on his legal advice? All right, seeing none, it appears that we have consensus. Just a couple of points, clarifying points from the chat. We do recognize the tremendous efforts of folks that have taken time to be with us, and we do apologize for the place that we find ourselves in, which is a place in which we're not able to take public comment pursuant to our attorney's advice today. I will pledge that the lineup that is set up right now can be the lineup for public comment when we do it. If that is workable. Seems like if you've already signed up, you ought to be able to go first in line. I think that we could do a public comment. I think that the hearing officer's recommended order had public comment the afternoon of the 10th. Ms. Larson, putting you on the spot, is that accurate?
Yes, Mr. Chair, that is accurate.
I think what we could do is we could roll into the afternoon of the 10th and then the evening of the 10th, perhaps, to provide 2 sets of public comments, one for those that are better equipped to do it during the day and one for those that are better equipped to do it during the evening. Ms. Larson, if you could work with our public commenters to try to accommodate that. And then we would take the, if we adopt the hearing officer's recommendation, We would take the 11th off. That is a federal holiday, Veterans Day. That is a Wednesday, and then we would reconvene on that Thursday and Friday, and then into the following week. For Commission or Hearings Officer Larson, the recommended order also suggested 5-page of written briefings, not pre-filed written testimony on the 10-9 drafts. Is that accurate?
That is correct.
Okay, and then it also, so it sets up the deadline to file those responses on November 4th at 5 p.m. Deadline to file written Rule 510 statements is also November 4th at 5 p.m. We would take up the rulemaking on November 10th. We would do public comment on November 10th at 1 p.m. And then we could also do public comment that evening, perhaps from, say, 6 to 8 or something like that. I'm making this up. Does that work with folks? Or 6 to 8 or 9, whatever. And then we would start staff and party presentations on November 12th, not having a hearing on November 11th in observance of Veterans Day. And we would anticipate completing the 1200 series by November 20th. That is all part of the proposed recommended order that we received. I would say a couple of other things. For public commenters, if November 10th does not work for you either during the day or in the evening, please do know that you still have the opportunity to provide us with written public comment. And I also would encourage folks to take a look at the 10-9 draft and the 10-9 statement and basis and purpose. Since we've developed this additional time, commissioners would like to receive input on that. And the only other thing that I would suggest to commissioners that I sort of see as a unintended, slight bonus is we are due to take up the 900 series on October 26th. And what I think this does provide is I would anticipate, as has been the course, that we will receive a red line to the 900 here fairly shortly. And this does provide all of our stakeholders with the opportunity to dive into that document and spend their time on that without having to spend their daytimes doing rulemakings on 1200. Perhaps that also provides some additional opportunities for collaboration and consensus building on the 900, and I would encourage that. Finally, I would like to send a thumbs up to staff. I know that you have been working tremendously hard. I had engagement with stakeholders over the weekend after the draft was released. And while there was some that were over here on this side and some that were over here on this side, there was uniform consensus that this is not something that we should blame staff on at all, and just recognize that we are asking staff to continue to help us with the Herculean task of mission change rulemaking. So Director Murphy, please tell staff we appreciate them, we understand, and we do not accept apologies. We're all doing Herculean efforts. So thank you very much. Are there other thoughts, questions, concerns? Commissioner Putnam.
Thank you, Chair Robbins. I just want to flag one schedule piece, which is on November the 10th from 1 to 4. The Hazardous and Solid Materials Division will be having a stakeholder meeting on technologically enhanced naturally occurring radioactive materials, or TNORM, focused on the oil and gas sector. I think given that this would extend into the evening, people would have an opportunity to engage in both. So I wanted to flag that, but I'm not sure that necessarily requires a change in schedule. And thank you to Sean Hackett for catching that one.
Thank you, Mr. Hackett. Again, you believe that that does not necessitate a potential schedule change, but just to let everybody know that that is happening. And if you wanted to participate in the TNORM discussion, then you would necessarily should sign up for evening public comment, I guess.
That's correct, Mr. Chair. I think you can do both, so I'm not recommending a change, but wanted to flag that in case anybody had concern.
Thank you for that. Are there other thoughts, questions, concerns from commissioners? Director Murphy, do you have anything that you would like to add? Okay, thank you. AAG Davenport.
Thank you, Mr. Chair. If it's acceptable to you, I'd like to suggest, if it's the commission's pleasure to grant the joint motion to continue, then I think the simplest motion language is to simply have a motion to adopt the hearing officer's recommended order.
Is that two motions or one motion?
It's just one motion to adopt the hearing officer's recommended order, unless, the only caveat being, of course, unless the commission does not wish to grant the joint motion, or if there is a specific provision in the hearing officer's recommended order that you would like to change, then that should be part of your order as well. But if you are prepared to grant the joint motion and to adopt the hearing officer's recommended order as it is drafted, all you have to do is move to adopt the hearing officer's recommended order.
AAG Davenport, not to get too persnickety on this, but we are not fully granting the joint motion because we have not taken them up on the pre-filed written testimony piece.
That's right. And so that's why I do not recommend that you move to grant the joint motion, but instead move to adopt the hearing officer's recommended order.
Okay. Thank you. Unless there is further discussion, I guess we would look for a motion. Commissioner McGowan.
Sorry, just to clarify then, folks who needed that additional time to look at the red line and give additional comments, that will all still be done verbally through testimony. Not additional written, correct?
So the way that the hearing officer's recommended motion is crafted is parties are allowed to file 5 additional pages of written test or briefing, basically briefing materials on the 10-9 documents. And any other interested individual is allowed to file a written 510 statement. And all of that is due on November 4th at 5 p.m. And then we would move into hearing on November 10th with public comment, as well as November 12th for our normal party participation.
Okay, that's what I thought the motion said, but so I think I'm confused about what AAG Davenport was. I'm good. If that's what we're doing, then I understand. I'm good. Thanks.
Mr. Chair.
Commissioner Messner.
So I will make a motion to adopt the hearing officer's recommended order.
Very good. Do we
Second.
have a motion and a second. Is there discussion on the motion? Seeing none, all those in favor indicate by saying aye.
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 Are there any opposed? Seeing none, the motion passes. And for better or worse, I think that concludes our business today. And I believe we are looking for a motion to continue this hearing until November 10th at 1 p. Is it 1 p.m. Commissioner or Hearings Officer Larson?
Yes, 1 p.m.
Are we
AAG
continuing
Davenport.
to October for the 900? Isn't that going to be our next thing, Mr. Chair?
Yeah, let's look to AAG Davenport for guidance here.
You've already continued the 1200 series, of course, to November 10th at 1 p.m. I think all you need is a motion to adjourn until October 26th at
Okay.
9 a.m. Is that correct, Ms. Larson? Are we starting at 9 a.m. on the 26th?
Ms. Larson, we couldn't hear you, but it looked like you were saying yes.
Yes. Can you hear me now?
Yes.
Thank you. Yes, 9 a.m. on the 26th of October.
Okay, so we're looking for a motion to adjourn until 9 a.m. on October 26th. Commissioner Manjapa, thank you.
Second.
We have a motion and a second. Is there further discussion? All right, seeing none, all those in favor signify by saying aye.
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 Any opposed? Seeing none. Thank you to our stakeholders. We think that this is the best result and will allow for proper 900 series and then 1200 series to conclude our mission change rulemaking. So we thank you all very much for your continued patience with us and your participation. And we will take up the 900 on October 26th at 9 a.m. Thanks, everybody.